And like, what's even occurring? Did I give us the one? I should, I know I need
That's what I'm worried about.
I'd walk away.
I would literally.
Oh, no 50s, I want plus that. If we all said no.
Okay. Has anyone used, have you had the seat gen thing in your other classes? No one's done that yet. I don't know whether you can seat yourself using it or whether I have to seat you. I'll figure it out, and on Thursday we'll do a seating chart. And that'll help you know. Okay. Let's talk about what we talked about last time. So you'll recall there are three big topics in this course, right? Is there a contract? Assuming there is a contract, what are the parties' obligations under it? And assuming the contract was breached, what's the remedy? We're on the first, and under that first two big headings, what does it require for there to be a contract? An agreement plus consideration, right? And then once we go through those two topics, we get to defenses against contractual liability, which are also important on whether or not there's a contract. So we're on consideration, and that was basically the topic last time, is what is consideration? What is this thing that you have to have in addition to the agreement in order for there to be enforceability? The modern test is the bargain test, right? And the bargain test says basically the agreements that we're going to enforce are exchange agreements, where there's a quid pro quo, just for that, right? There's someone is the promisor, the person who's undertaking a commitment, is doing it for a price because they'd like to receive something in exchange from the promisee. That the flip side of that definition of consideration, you can't read what I wrote. What did, see that like? Intended contract consideration, adequacy of mixed motive, release of claims, and then I've got the pre-existing to-do rule. And we're going to talk about the old rule today. The flip side of the exchange theory of consideration is that we just don't enforce gift promises, right? Our gratuitous promises. That unless we do, but the basic rule is a gratuitous promise is not supported by consideration. Now that supplants the old rule, the old account of consideration, which is either a benefit to the promisor or a detriment to the promisee. Kirksey v. Kirksey, the facts and holding sort of illustrate that old rule, the detriment is not enough. We need a benefit, we need an exchange. The mere detriment to the promisee is not enough. And then, so detriment is not sufficient, and then Hamer v. Sidway, that's the uncle's promise to the nephew, illustrates that benefit and detriment also aren't necessary, right? Because there's no clear material benefit to the uncle or detriment to the nephew, and yet there's clearly an exchange. The uncle is asking for the no drinking, smoking, gambling as the price in exchange for the promise of money. That said, right, that doesn't mean that benefit and detriment are irrelevant. So first off, in order to determine whether or not there is consideration, very often a benefit to the promisor suggests that what's being asked for is being requested in exchange. So Langer v. Superior Steel, that's the pension case. The fact that this that the promise was conditioned on the retired employee, the plaintiff, not working for a competitor, the fact that that condition benefits the company suggests that it's the price that's being asked for in exchange for the promised pension, right? And so that the promised pension is supported by consideration. But the benefit is evidentiary. It's not the actual test. The test isn't whether there's a benefit or detriment. It just goes to help show that there is consideration. That said, we're in the world of the common law created by courts. We don't have statutes that, well, we have some statutes, but old rules die hard. So courts are always looking at past cases and using past language. So you still see the benefit detriment language appearing in cases because we don't have a sharp line between old rules and new in the common law. It's an evolving system. So benefit and detriment also help us with the distinction between conditional promises and promises for consideration. So a conditional promise is a promise that if X or if you X, then I will Y. Promises with that form. Now, an exchange promise is always conditional in form, right? It's because if you give this to me, then I will undertake to do this for you. So all exchange promises are conditional, but not all conditional promises are exchanges, right? So if you will come and see me, if you will move your family and come and see me, I'll give you the house to live in. There's a condition, but because it doesn't obviously benefit the evil brother-in-law, it's not an exchange, right? It's not the price of the promise to give her the house. So benefit and detriment helps us distinguish between, again, conditional promises and promises for consideration. Mere conditional promises, right, that are not for consideration. The last piece of this kind of bargain theory of consideration, which we didn't really have a case for it, but we talked about, was the fact that it's an objective test. So what makes something consideration is that it was sought after. That's in the words of the second restatement, right? It was sought after as the price. That looks like a subjective state. But what we care about in looking at agreements in the consideration test is whether it looked like an exchange, not whether the subjective inner reasons of the individual. That's the object. So when I use subjective and objective in this course, that's what it refers to, right? The actual intentions, which the other side might or might not have known, versus what a reasonable person standing in the party's shoes would have understood those motives or intentions to be. And so the test for consideration is an objective one. We've also already started to see that consideration is not the only path to legal enforcement. So first off, in Langer, right, we've already, and we're going to see it again today, we've got this idea of promissory estoppel. So maybe in the absence of consideration, there's another way you can get to enforcement. We'll see that cropping up again and again, and the promissory estoppel is sort of an alternative to consideration. Will be it'll appear again and again in this course. It'll appear actually not just as an alternative consideration. Another path for enforcing a gratuitous promise used to be the seal, right? So we had this formality that you put it in writing, and you put this sort of magic legal symbol or sign on it, and that would get you enforcement whether or not there was consideration. But in the late 19th, early 20th century, state legislatures passed laws in various ways, sort of robbing the seal of that power. So, and that's the decline of the seal. So today, putting it into a sealed writing in most states or U.S. jurisdictions isn't enough, and we saw that in Ray Green, right, where the New York statute says that a seal creates a presumption of consideration, but that may be rebutted, right? Whereas prior to that law, prior to that statute, the rule was, it was categorical. It didn't even matter whether you had consideration. So what does that mean? Now we get to the beginning of intent to contract that we're going to talk about more today. That generally speaking, the mere intent to have a legally binding agreement is not sufficient to get one in the absence of consideration. That's in Ray Green, right, with the decline of the seal, and also that's consistent with the peppercorn rule, which is that a mere peppercorn, $1 in exchange nominal consideration is not consideration. We have to have enough of something in return that we can tell a plausible story about it being a reason to enter into the transaction. And then in Ray Green, the dollar was not mere recitals of consideration or not. That's also in Ray Green. And then so intent to contract is not sufficient to get a legal obligation. And then today we're going to start talking about whether it's necessary, right, to have a contract. Necessary versus sufficient, right? It's not enough in the absence of consideration. But if there is consideration, do we need to show that there's an intent, that the parties wanted legal liability? And when I say intent to contract, what I'm saying is, did they intend to enter into a legally binding agreement as opposed to just an agreement? Okay. Any questions about any of that? Or all of it? No, really? All right, great. Really awesome when you put on your sport coat that you haven't worn all summer and you find a nice pin. Aaron Rogers. Yes, Aaron. Okay, great. So these are kind of interesting facts, aren't they? Yeah. So what's the promise here?
The promise was.
Or just what are the facts? I don't need to.
Okay. Sorry, I'm looking for
This is the reporter case, right?
Yes. So Cohen separately approached the two reporters with documents, and he said that if they promised him to keep his identity confidential, that he would hand over the documents to them.
Great. Okay, let me just stop you there because that's a great statement of exactly what the offer Cohen was making, right? Who's the plaintiff here? So that's a conditional promise. I mean, he said it's a conditional offer. If you promise, then I'll give you. So is there consideration there? I mean, not every conditional promise has consideration, but what's your sense of this one? Is that an exchange?
Yes, I would say yes.
Yeah, right? I mean, it's like, I'll give you the documents if you give me a promise of confidentiality. And the reporters on their part were like, yeah, we'll give you a promise of confidentiality if you give us, we want the documents. He wants the promise of confidentiality, right? So it's an exchange, it looks like an exchange, and we've got an agreement. And then what happens?
The reporters end up revealing his identity.
Yeah, right. And you remember why?
It was because the editors had a conversation and ultimately decided that they were going to reveal his identity because when they went to try to discover the actual court documents, they found that someone that worked with him had already recovered the court documents.
Mm-hmm. This is all part of it. This is in the context of a political campaign, right? And the documents kind of are trying to smear the EFL, Democratic, is anyone from Minnesota? Democratic Farm League? EFL, anyway, the Democratic Party in Minnesota. The Democrat candidate, right, turns out he's a Republican operative. And so what's the real story? Not this old sort of misdeed of the Democratic Party, or that's what the editors decide. What's the real story? Well, this is Minnesota. What do we know about Minnesota? Everybody's really nice. Everybody's really nice in Minnesota. Nobody's from Minnesota. Yeah, right, is everybody really nice?
Yes.
Yeah. It's practically Canada. Everybody's real, I mean, all right, that's just a joke. But what's the real story? The real story is that the Republicans are trying to smear this Democratic candidate, right? That's like the source's identity is actually as interesting or important a story as is anything else, right? So, and in fact, it's two newspapers, right? Both get, and they both decide that's the real story independently. So it's, so, and then what happens to him afterwards?
He ends up getting fired.
He ends up losing his job and suffering real losses. So, okay, so he sues, right? And we've got, he sues on multiple grounds. One is, the court mentions defamation. So you should all know what defamation is at this point, yeah. I mean, because of our precedent, right? What?
Fraudulent misrepresentation.
Good, but not, no, right? That's the defamation is just mentioned in passing. Who sues and is getting sued for defamation a lot?
Media?
Donald Trump. Yes, the media. That's in Britain, though. The media has a lot of protections against defamation. But the court says in passing, no defamation here. Why? It's true, right? That's why Donald Trump lost. It's true. So, but there was also a fraudulent misrepresentation claim, and what does that seem to be?
It seems to be that. It's the misrepresentation of a past or present fact.
Yeah.
But they're saying that the revealing or not revealing of Cohen's identity is a future act.
Yeah.
So therefore.
And so what the claim was, we're going to get to this too. Don't confuse it. He brought a claim of promissory fraud. What's the claim of promissory fraud? Is when you enter into a contract without an intent to perform it, right? You enter into a contract intending to breach. We'll get to this. It's a tort cause of action. And with the tort cause of actions, this is why damages are important, you can get punitive damages, right? And and what's the idea of promissory fraud? That by entering into a contract, you implicitly represent that you currently intend to perform. You might change your mind later, that's not fraudulent, but at the time of contracting, if you enter into a contract intending to breach, that's like a form of fraud. And what does the court say about this fraud claim? Yeah.
Well, he said that the promises were intended to be kept the entire time by the reporters.
Yeah, and in fact, Cohen seems to admit that. That really, what happened was the reporters got overruled by their editors. So at the time the promise was made, the reporters kept. Now, why is this kind of interesting just as a procedural matter? What did the jury, what was, yeah?
Well, they entered in a verdict in favor of Cohen.
On the promissory fraud and awarded exemplary or punitive damages, right? And so this is one of the rare cases where we find an appellate court reversing a jury finding of fact or a jury verdict. I don't know if it was because the instructions were wrong, but we've got a jury who found promissory fraud and the appellate court said, look, there's just no facts to support that because Cohen admits that they intended to keep it. Yeah.
Why is it called promissory fraud? Like, what's the fraudulent portion of this?
So the key is it's a misrepresentation of your present intention to perform. So the idea is, so look, if I take out a loan from a bank, like when I'm on the edge of bankruptcy and I know that I'm never going to pay it back, but I want to just take the cash and run, that's promissory fraud because I'm promising to pay it back, but in fact, I'm not planning to pay it back, right? So that's where the fraud is. And so it is promissory because the idea is that a promise is not a statement of fact. A promise is an undertaking of an obligation. That's the first thing. That's what a promise is, right? A promise is like, it's saying something about the future. It's obliging yourself. But the idea is that the act of entering into a promise does implicitly represent that you currently intend to perform that, whatever you're promising. And it's fraudulent, so that's why it's promissory fraud.
That makes
Yeah,
Since they ultimately didn't have the final say and it was up to their editors, is there some argument to make that they were making a promise they couldn't keep?
yeah, so that's a really interesting question. I have an unusual interest in promissory fraud. So Ian, Eric, and I wrote a book on it like several years ago. Yeah, so right, because what you really care about is not whether they intend to perform, but you care about, are they going to perform? Like, what does the promisee care about? What's really, and so maybe there are these really interesting cases where, well, this is like a Ponzi scheme question. It comes up in Ponzi schemes, right? Like, what if the promisor is just like super over optimistic? Like, I really think, or it's also like in Silicon Valley, right? All the time, because they're like over promising is part of the cultural currency in Silicon Valley. And so what and certainly at some point, unreasonable optimism turns into fraud, right? You should have known. But it's like, those are really interesting borderline questions, yeah.
I feel like in this case though, they said that this had almost like never happened. Like they had never seen anything like this happen before, where the editorial
Yeah.
staff overruled the report.
Right, exactly. So in this case, right, you might say, interesting question if you sort of don't have the power to promise. Like, what about if you don't. This is not about the probability. The probability was very high that they would be able to perform in this case, but they maybe didn't have the power to. On the other hand, like, reporters make these promises all the time without checking with their editors first. So it is weird. Okay, yeah.
Oh, sorry, just on that point, could it be similar to the nose job case where this is common practice and they had a good reliance?
Well, so the interesting thing about fraud, and we're going to come back to this, so is there's a requirement of reasonable reliance on the statement of fact, right? And so in some contexts, it might not be reasonable where there's systematic puffing or sales talk. It might not be reasonable to rely, and that might be Silicon Valley for all I know, right? Unless you get into really factual lies, but all those future-oriented statements, it may not be unreasonable. But okay, that's just a sideshow here, right? Because what this is really about is, can they enforce it in contract? You've already said there's consideration, and the court agrees with you. We know there's an agreement, right? So yeah, there's a contract, right? Except no. What does this court say? Yeah.
They said that it wasn't enforceable because in these promises between reporters and the people that they're dealing with, they usually don't intend to create a contract with them.
Yeah. And it looks, right, so, and this is sort of what I was going to state, this court suggests a very broad rule on page 99, right? The law does not create a contract where the parties intended none, right? So if the parties didn't intend a contract, it almost looks like, the way they state the rule so broadly, it looks like it's a third element for the contract case, right? Agreement, consideration, plus they have to have intended to contract, yeah.
If you continue on 99, I found it interesting that it also talks about the unwarranted legal rigidity on a special ethical relationship.
Yeah.
And I feel like that was the first true introduction, potentially, explicitly, at least in the case where it says there's another element to a contract that perhaps we've almost put to the side.
Yeah. This is actually like, and you know, we talked a little bit about consideration and why consideration, and maybe it's, we're okay with exchange promises, sort of the law backing those up, but a gratuitous promise is a place that we want to protect from from the rigidity of contractual enforcement. And it turns out, well, maybe some exchange promises are the same, right? That's a policy argument. That's not like intent to contract, although maybe that intent to contract would work to sort of like as an additional element to protect those kinds of promises, yeah.
I thought the line where they said they are not thinking in terms of offers and acceptance in any commercial or business sense was super interesting, because it seems to me that this is like obviously a commercial setting. Like, he's doing his job, and getting the story is literally going to help the newspaper like make money and attract.
Yeah, although, you know, like, being a reporter is such a noble profession. I mean, you know, I mean, it is a noble profession, right? I mean, this is 1990, this is after Watergate, and so, you know, you've got like all the presidents, like, you know, Woodward and Bernstein, and this is kind of like, and I do want to, that's a kind of a joke, but the court does also emphasize what? That there are journalistic norms that are really, really strong here. And they didn't take this decision lightly. So there's sort of like, the law, this goes back to interfering with in this area, sort of, and maybe it's similar to a doctor-patient relationship. I mean, in this respect, that there are professional norms that make these, that protect promisees here. And that are maybe, the law is less warranted, right? It's not purely commercial. Although, you know, there are obviously, like, the paper's reputation matters, and I'm not saying it's purely benevolent. Yeah.
Yeah, it seems kind of similar to like how there was a debate about whether things should apply to doctors in the absence of like a clear promise, and that created a clarification of what the standard for a promise would be in that sort of special.
Right, and this is saying, like, so after Cohen in Minnesota, if you're talking to a reporter and you want a promise of confidentiality and you want it to be backed up, what do you need to do?
Somehow make it commercial, which is weird. Like,
Yeah, or just say, hey, look, just tell me that you intend this to be legally enforceable. Like, your mere promise of confidentiality is not enough for me. You know, let's just execute a document saying that in exchange for the information you've given me a promise of confidentiality, and I have the right to sue on that. Right, so just say that you intend to contract in Minnesota, and that's enough. Why is this case so interesting? I mean, the court announces this as if it's a general rule, but what seems to be driving the case? The particular facts of the case, right? They're talking about the policy and the worry, and we haven't even mentioned sort of the elephant in the room here, which is that constitutional elephant, right?
Oh, I was just gonna say, I think it was in the comment, but it talks about the idea of introducing the First Amendment.
The First Amendment, right? So let's just, I'll come back to this conversation, but if you look at the summary, there was actually a third claim that was discussed, right? By the court, promissory fraud, contract, and then promissory estoppel. The court says, but maybe in the absence of an intent to contract, there should still be a promissory estoppel claim. Where are we? We're in the Minnesota Supreme Court, right? Minnesota Supreme Court says, all right, well, we think under Minnesota law, there could be a claim for promissory estoppel in the absence of intent to contract, which is a different use of promissory estoppel. But if there's a reasonable reliance, and we know we have different remedies, well, you will learn we have different remedies for promissory estoppel. What happens after the Minnesota Supreme Court decides that?
It gets appealed to the Supreme Court. And
Goes to the U.S. Supreme Court, right? Which says
that you can sue on promissory estoppel.
that you can sue, yeah. And but of course they're not really, they're not in charge of Minnesota law. What are they in charge of?
That's
What?
federal.
Federal law, right? So it's the constitutional issue that gets this case to the U.S. Supreme Court. The U.S. Supreme Court overrules the Minnesota Supreme Court on the constitutional question of does the First Amendment prevent an action for promissory estoppel. Again, of course, and if the First Amendment protected the action for promissory estoppel, it would clearly prevent the action from on contract as well, right? And the U.S. Supreme Court says no, right? And when if you take the First Amendment class, or maybe in your common law class, you'll find out that reporters don't have a lot of special protections under the First Amendment. So there are some, like in fact in defamation, the press gets very special protections, but not, for example, against being required to name your source. You know, reporters do. That's why reporters go to jail when they don't name their sources for contempt of court. Anyway, so the U.S. Why is all of this important? The Minnesota Supreme Court clearly does not want to enforce this promise, right? For public policy reasons, and maybe even because of their view of the Constitution. They think that there's a real important constitutional issue here. They don't want to enforce it, so they say, well, look, but that's not the rule they announced for the contract case. The rule they announced is, we need an intent to contract. What's super interesting about that? They announce it as though it's a generic rule, but what does the restatement say about intent to contract? Section 21, is that a hand?
It wasn't back in it.
Okay, that's what you get for scratching your head.
It basically says like, kind of going back to the peppercorn rule, that you can basically give anything consideration. They don't judge consideration.
Yeah, but I know, I want to look at section 21. Section 21, which is called intent to be legally bound. Yeah.
It says, neither real nor apparent intention of promise to be legally binding is essential.
Right, so, and I want to parse that really closely, if we can look at the second part of the sentence. Neither real nor apparent intention that a promise be legally binding is essential to the formation of a contract. So real nor apparent, what is that? Subjective, neither subjective nor objective, right? So this is it doesn't matter whether the party subjectively intended or objectively intended. If there's an exchange, there's a contract. We don't have an intent to contract. But that's exactly the opposite of what the Minnesota Supreme Court says in this case, right? So that's weird. I'll just go through the rest of the restatement rule. But a manifestation of intention that a promise shall not affect legal relations may prevent the formation of a contract. So what's the but? So there's no requirement that you intend legal liability, but what?
If you specifically say you don't want to, that's enough for it to not be a contract.
Yeah, exactly. So the default, you might say, is we enforce exchange agreements unless you tell us you don't want it enforced. And so what I'm going to call these are, no one but Ian and I use this term, but we're working on it. Tinalia clauses. What's a Tinalia clause? This is not a legally enforceable agreement, right? So if you put that, I'm not talking about reporters' promises now, right? I'm talking about normal commercial transactions. You put that in your, you write it down, and you just agree that this is not a legally enforceable agreement. That second clause says then you've expressed your intent that it not be legally binding, and courts will generally respect that, right, in the normal case. So let me just step back. So right, we know from last time that intent to contract is not sufficient. What does section 21 say? It's not necessary, right? It's not necessary, objectively or subjectively, except what does Cohen say? Except when it is, right? So the Cohen announces this as though it's a really broad rule. Why are we reading Cohen? I mean, it's just a great case. It's really fascinating, but in part, it's the exception. We're reading this case because it's the exception to the rule, not the rule, right? That's what's so interesting about it. And what's the court doing? And in fact, like if you look at, which I have done now, if you look at reporters' cases for breach of contract based on a reporter's case of confidentiality, most courts follow Cohen, right? They say in the subclass of promises, we're going to say they're not legally enforceable unless the parties say so, unless the parties express their intent. Yeah.
So is there any other situations like this that the court considers an ill fit?
Yes.
An exception to the rule?
Yeah, it always bugged me that Burton and Eisenberg don't publish the comments to section 21, but the comments to section 21 suggest that social promises and agreements between family members don't give rise to legal liability. So, if I invite my friend Amy over to dinner and I'm like, hey, I'm cooking dinner, how about you bring the wine? I'll do the food, right? Looks like an exchange, but if she doesn't bring the wine, I can't sue her. Now, so that's a social promise. And what's so interesting about this is in England, the rule on the books, what we call the black letter rule, is the opposite. In England, courts say that there is a requirement of an intent to contract And so like when contract theorists from the US and England are in the same room, we have like these crazy debates. What are you talking about? Because they're different rules. But where does that come from? It comes from Balfour v. Balfour, this early 20th century case where it's about, the husband is like going to India, like, you know, with the British Foreign Service or whatever, and he promises his wife that he'll send her money if she like keeps up the house and stuff like that, right? Exchange promise between spouses. And you read that opinion, and it's all about like a man's house is his castle, and the law doesn't get. I mean, you laugh, but right, it's, you know, this is actually, there's a real deep sexism going on at the time, and it was kind of protecting this private sphere against interference by the law, because but in English courts then read Balfour v. Balfour to be a generic. It's like if we read this case to state the rule for all contracts. And so in England, courts often recite that there's a third element, an intent to contract. But when you look at the cases, they only apply the requirement where there's a kind of a social, where the court is uncomfortable with legal liability in this area. And you see that also in the notice of the restatement, right, where they say, and we will see elsewhere in the courts. There are other examples where the courts do look for an intent to contract. But we've seen the first one now, which is reporters' promises. Yeah.
Just stop me if this is like too tangential, but the two like problem questions we did then under Cohen, because it's kind of between family members.
Yeah, so right, so
contract.
this is, let's talk about the one that's right after this case, right? We can jump there now. That's you know, where is it? Oh, the case of the no hassle house, right? So, you know, these are interspersed in books. Sometimes we'll talk about them, sometimes not, but they're always worth thinking through because, and there are no right answers to these kinds of questions. But right, so they're the husband and wife are separating. They're not divorcing, and he says, "You can keep the house if you just leave me alone." Right? Is there consideration? Yeah, it looks like it, right? And she leaves him alone, so she performs her side of it. And then what happens? He dies, and his heir, his brother, attempts to murder her. So, yeah, what outcome?
I mean, before you said like social promises fall under the Cohen category, I actually said that this was an enforceable promise. Let me go back to what I said.
I agree. I mean, like, it looks like a promise for consideration. I can agree with, like, what else do you need?
Yeah.
Yeah. Yeah. And notice the case, I mean, a lot of these problems, not all of them, some of them are super fantastical, like the Penny case. But this actually is the facts of an actual case. But where's that case from? I mean, it has a really weird citation. Ferris v. Weaver, 1950, with all ER 233. No reason you would know this. That's an English case, right? So it's a case, I mean, so under the English rule, it would seem, Balfour v. Balfour, it would seem like, well, no, this is a husband's promise. Should it be enforceable? Yeah.
Could you read, I don't want to go to court over all this?
Oh, good, yeah.
Like, explicit intent not to contract?
Great. So, I mean, read the facts super closely. Maybe there's an intent not to contract here. And so this is sort of like, he's saying, let's keep this out of the courts if this is just between us. In which case, even under the English rule, even under the American rule, even under section 21, that second clause, he'd be saying, I don't want to go to court, right? Yeah.
I feel like it makes a big difference that they're still married, like legally married at the time that she's suing him for breach of contract, because he held it in his name throughout the years and paid mortgages. So like, I feel like courts would be uneasy with like interfering in like what is still technically a family relationship. like if they were divorced, it would be
What's
different.
interesting is they seem to have opted out of the default, which is joint with several, the property is joined, it was held in common, but he held it in his name only. So they seem to have like agreed to that, although that may also make the courts comfortable going the other way. Like, doesn't she have like sort of a moral claim to this house that, yeah?
I'm a little confused why there's a consideration, because it seems to me it's like the Kirksey case, so it's like, if you come to see me, it's like, if you leave me alone, it's like, there's no exchange.
Yeah, I think the difference is that if you leave me alone, seems to be what he wants out of her, right? So it seems to be the price. Just don't hassle me, and you can have the house. Whereas otherwise, she would, you know, bring claims for this or that, and so he's basically, I mean, saying, leave me. So unlike if you come visit me, which seems like, it's not even if you come see me, it's like, you have to, that condition, the way the court read it, right, was not the price of getting the house, it was just what she had to do to occupy the house. It wasn't something that benefited him. Whereas here, this would be the argument for consideration, he wants her to leave him alone.
So it's, one is like beneficial, one is like grab.
Exactly. Remember, benefit can be evidence of consideration, even if it's no longer the test. Yeah.
I feel like I don't want to go to court over all of this could also be read as the husband acknowledging that he wants to maintain title of the house.
Yeah.
Because if they did go to court and they had to legitimately separate, she would have some claim to that.
Yeah.
So perhaps he did go into it with the intent of eventually benefiting off of this title of the house and selling it to his wife.
Yeah. Yeah.
Well, if she has other claims against him, say, like maybe it's in case I don't want to go to divorce and have to.
No, so maybe
assets.
leave me alone is actually, so one is, these cut in different ways, right? Like he's trying to keep the house. Of course, remember, our tests here are always going to be objective. It's not what he secretly thought, it's what's the most reasonable understanding. But that's a reasonable reading of what's going on here. I just want to, it's not what he secretly intended, it's what she would reasonably understand. And maybe it is keeping the house, this is all about, we're not going to go to court, we're not going to divide the property. On the other hand, maybe this is more like a settlement of claims, right? Like maybe that if you just stop passing this, if you don't bring an action for divorce, I'll let you have the house. In which case, it starts to look much more like a legal kind of transaction.
Hamer v. Sidway?
Yeah, or Browning v. Johnson, which we're going to discuss later on, yeah.
Like, I feel like I might be jumping too far ahead here, but like, in order for this to become an agreement, does each party have to like let each other know that they intend on following through on this promise in order for a contract to be formed?
I mean, so I've said there needs to be an agreement and there needs to be a consideration. The agreement really just has to be a manifestation of we both want this exchange to happen. It's not just want, but we are hereby agreeing to it, right? And I think that's here. It doesn't have to be super formal though, right? An agreement can be oral. It doesn't have to be in writing. It can be even in the first case when we get to that is just an employer talking to an employee in a way that doesn't even say you're hereby hired. But the employee reasonably understood. And so I think this matches the agreement. This satisfies the agreement requirement. In fact, I know that.
With the test being a reasonable one, what a reasonable person would think what the exchange is? Does what's reasonable really depend on the facts surrounding the case?
Yeah, so this is very bare bones, but if this were litigated, when it was litigated, you'd probably have a lot of more evidence about the surrounding circumstances, like the statement of facts in the case is very bare bones. And let me just say, and then we'll go on, this is totally typical of an exam question, right, or any hard legal case. It doesn't go to court unless there are arguments on both sides. And so this would be one of those cases where even if the law were clear, which is not entirely, but even if the law is clear, the facts in this case are open to different interpretations. And so if the more evidence you have, right, that should make it easier to decide which one is correct, although not always. But what would you want to do on an exam? You'd want to identify all of these possible, you know, like, he will argue, or his brother will argue this and this and this, and she will argue, no, this and this. And then, you know, that's the project of speak up the law and facts, yeah. Not getting the right answer.
Can I ask a question about Cohen?
Yeah, of course.
So, just so I understand specifically how we're supposed to read it, this is the case from the Minnesota Supreme Court. So, should we be taking the holding from that case and not what was, because
Right.
it's ultimately reversed?
But it was reversed on constitutional grounds. So first off, what was reversed was their holding with respect to promissory estoppel, right, which is not promissory fraud, but promissory estoppel. What they say is he relied on their promise, but the First Amendment prevents it. The U.S. Supreme Court reverses on the First Amendment, but the U.S. Supreme Court has nothing to say about Minnesota law, right? So the U.S. Supreme Court doesn't reverse any of the contract. So certainly, what the Minnesota Supreme Court says about promissory estoppel stands. But obviously, like, there was no appeal with respect to this finding of no breach of contract, this holding of no breach of contract, because there was no intent to contract.
Okay.
So that didn't get appealed. The breach of contract piece didn't get appealed because they said, why is all that First Amendment stuff interesting? Because once again, right, this is a sort of like public policy considerations of protecting certain relationships from contract law. How do we do that? Not just by saying we're not going to enforce these. The way this court does it is by, I mean, in Sullivan v. O'Connor, we saw the court doing it by saying clear evidence of a promise, and we're going to award a lower damage measure, right? Here, the court is saying something different, which is we want to know that they intended legal liability in this class.
So he essentially still received the damages.
He does not. He does not because he can't show intent to contract. That's what they're saying. He's the plaintiff, right?
Right.
And what they're saying is that normally here, the default is unless you say that you intend it to be legally binding, it's not. Unless the reporter, and here there was no sort of clear evidence that they intended it to be legally binding, so he loses. Yeah.
I just have a question about like precedent and contract law in general. Like it seems like so many of the cases we're reading are specific state courts.
They're all. There's no.
Yeah, so I guess my question is like, to what extent, and I assume it's a lot, do states try to follow the precedent of other states in establishing sort of like a uniform reading of contract law precedent?
Yeah.
Or are there like contradicting precedents?
Yes, so we're going to see splits among jurisdictions. Yeah, there are, so yes and yes. There are splits among jurisdictions on some very important questions of contract law. We don't have one law of contract in the United States. We have, 50 some odd districts in Guam and Puerto Rico also have their contract laws, not just the states. So courts can come up with different rules, and they do sometimes. That said, so what's the opposite end of the spectrum? We haven't hit any uniform commercial code cases yet, the UCC. What's the UCC? It's a model statute that states pass, and the UCC was designed so that all the states would have the same rules. It's contracts for the sales of goods, and courts tend then to look to one another because uniformity is the whole goal of those statutes, right? So it's a mix, but different states have different policies. This is federalism, right? Like the laboratory of democracy. Different states have different policy preferences. We know that, like today more than ever, the different states have deeply different policy preferences, including with respect to commercial preferences. That's why it's maybe important that Minnesotans are nice. I mean, it'd be different, right? It might be different in California. I'm not saying Californians aren't nice, but California might feel differently about sort of like messing around, having the law get involved in these reporters' policies. Yeah.
So another question on Cohen is that there's actually I remember like it's not completely related, but I remember there's like a trope in like TV shows and movies where in order to establish like attorney-client confidentiality. The client often pay like the lawyer, say $1 bill or something. I wonder if this is like related to the rules established in Cohen.
No. I mean, but I see where you're going, right? Because it is a kind of a special professional relationship. And, but what we end up finding is that the attorney-client relationship is much more heavily regulated than the reporter-source relationship. And I think that way of thinking kind of crosses those boundaries. But in fact, from the law's perspective, there is no sort of confidentiality in the way there is with the attorney-client. Maybe that's just, I mean, there's lots, we don't have to go into why. Okay, let's keep going and talk about, okay, intent to contract, neither necessary nor sufficient, except when it is necessary, and except when it is sufficient, right? Does that make sense? Okay, let's talk about Thomas v. Thomas, at least the first one. Then we can take a break. Henry.
So this is a case between.
You both have the same last name, by the way. You do. Just saying. Yeah. So what's the case about?
The 19th century England plaintiff is Eleanor Thomas. Defendant is Samuel Thomas, who's dead, and so it's actually his executors.
Right.
And so the husband, Samuel Thomas, defendant, at the time of his death, owned 7 houses.
Not actually the defendant, right? But he's dead.
Yeah. The husband.
The dead husband.
The dead husband owned 7 houses at the time of his death. On his deathbed, said that he wanted to provide for his wife either the house in which he had lived, because he had lived in one of the 7 houses, and all of its contents, or a sum of £100. He dies. Then the defendant comes in and wanting to respect the wishes of the dead husband.
Yeah, and just to be clear, the defendants are. I mean, they're his brothers, but what's their role in all of this? We've seen it.
The executors of
They're the executors of the estate, right? She's suing the estate, and they're the 2 brothers of the dead husband. Just to pause, why isn't his deathbed promise just enforceable, right? Like as a will, it's a bequest. I mean, we know that people can determine what happens to their property after they die. Yeah.
He like announced it like a day before he died. It wasn't actually in his written will.
It wasn't in the will, it was an oral statement of what you want to happen to your promise is not a bequest. In order to, and this is where wills are very different from contracts. In order to have a legally binding last will and testament, you have to put it in writing, you have to sign it, you may have to get it witnessed, depending on the state, right? There's a lot of formalities around it. He didn't do any of that, so his deathbed expression of intention doesn't change where his property actually goes. And he's written some kind of last will and testament. Normally it would go to his wife, but he's written a last will and testament that doesn't, and his oral statement doesn't write. But anyway, yes, in consideration or.
Yeah, they basically, they still want to respect the wishes of their brother, so they agree to they basically create a written instrument, I think, with witnesses that says that they will provide her with one of the houses for a sum of £1 yearly, as well as kind of keeping the premises in good and tenable repair.
Yeah, and then we've also got this wonderful statement in the writing, right? Now these present, I'm on near the top of 119. Now these presents witness and is hereby agreed and declared by between the parties that in consideration of such desire, right? Such desire being their desire to honor their dead brother's wishes. Right, we're here right now, is that consideration?
And the concurrence says that it's not, because it doesn't flow from the plaintiff to the
Yeah, I mean, like your dead brother's wishes, that's just a gratuitous promise, right? She's not doing anything in return for it. So like in a way, it's a weird instrument because it's clearly like drafted by lawyers. It's got all this lawyer speak in it. But it says in consideration of something that's not consideration, right? Their desire to honor their dead brother. But what?
But Pattison in his concurrence talks about the fact that that's not what the consideration is. Consideration needs to flow from promisee to promisor, and therefore it is the £1, which is sufficient consideration.
Yeah, but that you might say is one nominal.
I mean, they think it's sufficient. It's also, I mean, it was 140 pounds or something like that.
Yeah, if you can go online and do some calculator, like using the different price indexes.
It does seem
It's
nominal.
it's like, you know, a couple $100, maybe 300, yeah.
Does the fact that it was £1 payment yearly affect the fact that it's not nominal?
It's not just a one-time payment, right? It's every single year. That makes it look a little bit less nominal, right? A pound did have more meaning in, you know, 150 or, you know, almost 200 years ago, right? This was the time when, like, I don't know, what was Mr. Darby's annual income? 10,000 pounds or something? And he was a really great catch. You all know what I'm talking about, right?
Pride and Prejudice.
Thank you. Yeah. He was, I think it was 10,000 pounds a year. Like, anyway, you know, like all those Jane Austen novels, like 10,000 is a lot of money. But that doesn't mean that 1 pound is a lot, but it's a lot more than, like, you know, 10,000 is the equivalent of $1 million today. And it's paid annually, so it's not just a one-time thing. But of course, and it's not just the pound, what else? She has to maintain the house, and that benefits them, right, because they're not giving her title. So she has to keep the house up, yeah.
Also, didn't they say that the £1 was not something that he had already been paying? Like, it was something that they asked for in addition, so that was like another benefit to
Another benefit to them, right? So all of these benefit the estate. So, of course, what's interesting is clearly that's not their motive or even their apparent motive, right? They say in their writing that their apparent motive is to honor their dead brother's wishes. Like that's what's driving this whole thing. But what, and I think this sentence is also sort of crucial, when Patterson, this is English cases, like this is how they were written at the time, where there'd be like all the judges would just write an opinion, and like, you know, they'd all say what they thought about it, and then you'd figure out the law from that. Motive is not the same thing with consideration, right? So their motive is to honor their dead brother's wishes, and that's what the document said. Objectively, they're objectively speaking, their motive is, but there's consideration nonetheless because there's an exchange. Their motive may be not just the exchange. So what does that mean? One way to think about that is consideration has to be a reason. It has to provide a reason for making the promise. But it doesn't have to be the reason, right? It doesn't have to be the only reason or even the primary reason. It has to provide a reason. This is something that they sought in exchange. But it doesn't have to be it doesn't have to be even enough to drive them to enter into the exchange. Does that make sense? No? So people do things for multiple reasons, right? Like very often you act for more than one reason. And in this case, it seems like the brothers are acting in large part for a gratuitous reason. But by structuring this transaction so that she's providing something else of value as a condition of her staying in the house, the transaction gives them additional reasons, right? So they're acting for this is mixed motive, right? They have mixed motives for entering into this transaction. And that's okay as long as some of those motives are an exchange, right? It doesn't have to be the reason, it has to be a reason. Does that help? Right? It's okay to have mixed motives.
So you're saying that if it's just that motive by itself, this would not be important?
If they just said, like, in consideration of our dead brother's wishes, you can stay here until you die.
Right, then it's just a gift.
That would just be a gift. And of course, you know, at least under the contemporary peppercorn rule in the United States, if they had said, in exchange for a one-time payment of, I don't know what, let's just call it like a shilling, whatever that is, less than a pound, then that would also not be enough. But by structuring this in a way that, yeah.
if you were trying to provide proof of consideration for the purpose of making it legally binding, like to the end of the original motive, so then like the consideration was like almost a reason for the primary reason, would that?
Say this again.
So like your motive is that your brother's wish is carried out, and you want that to be like legally enforceable.
Right. So I mean, so in other words, like, so first off, this is an interesting, that we know that there's a good brother and an evil brother, right? Is what happens here.
She gets kicked off.
Yeah, why? What happens before she gets kicked off? One of the brothers dies and the other brother kicks her off, right? So we've got a good brother, we've got, like it's so often the case, there's a good sibling and an evil sibling, right? I have a brother, by the way. But why am I mentioning that? Because this weird document that kind of says, it's saying in consideration of something that's not a consideration, like it itself looks like it's kind of mixed up. But it looks like, so is it a problem if they intentionally structured this as an exchange to make it legally enforceable, right? So their secret motive for putting it in an exchange form, not more than a peppercorn, was a gratuitous motive? No, doesn't matter, right? Because there is consideration. Because there is something actually that she's doing that's a benefit to them or to the estate. Does that answer the question?
I guess so, but then doesn't that seem like it goes more to nominal consideration if it is just being put in the purpose of like making it?
I mean, the definition of nominal consideration is something that doesn't provide you a reason. That's not the definition, but that we can't tell a plausible story that it's the reason why you entered into, or a reason why you entered into this exchange. A reason. And here, it is a reason. What they do does provide a reason for letting her stay in the house. And so, but yes, right? I mean, in other words, what you're saying is, like, intent to contract is not sufficient, but if you're sophisticated enough, the good brother can draft a document, right, that asks for something of substance in return from her over time, and that will count as consideration. So even if they don't, that's not really their motive, they can do, you can act for an exchange, you can do an exchange for gratuitous reasons. And we're okay with that. But of course, like all legal rules, at a certain point run up against, Charlie Chaplin in Modern Times, well, it's in Modern Times, right? Like he's totally homeless and he's hungry and he doesn't have a roof over his head and so what does he want to do? He commits crimes, like these petty crimes, so that in front of a police officer, so that he'll get arrested so he can go to jail and have a place to live and get food, right? Now he's misusing that law, right? But legal rules, that's how legal rules work, right? We design them for the normal case and then sometimes they get misused for the, yeah.
I see this, I'm just a little confused, like, I feel like it comes into tension with, like, the objective measure of consideration a little bit, because it's like, I mean, objectively, you could say that, like, their main intent, like, objectively, you could say in this case, there is consideration because a reasonable person would expect that to be, like, an exchange of some sorts, but then they're saying that it's not their motive, so it's like, well, then I feel like you're looking at it through two different lenses at the same time, if that makes sense.
Yeah, and that's why I want to really sharply distinguish. I mean, it is subtle, right? Because last time we were saying, look, what makes a consideration if it's sought after objectively, right? But that's a kind of subjective. It looks like motive, right? Like if it's something that provides. And now I'm kind of shifting, saying, well, all that matters is it provides a reason, even if it's not your true motive, right? And I think that's what this case stands for. That we're just saying what matters is that it provides a reason for entering, that we can tell an exchange story, even if it's not the underlying motive. Yeah.
Another structural question for the case. So, isn't Samuel Thomas the defendant in this situation? Because I was confused on how Samuel's name is first instead of second, but I didn't know.
Oh, yeah, you mean order of cases, just like order of names.
Yeah, it was
Don't
just
even,
helping
don't,
me.
yeah, don't even, do not read any, especially from an old English case, right? But the order of the names doesn't necessarily always reflect who the parties are. That's just the short answer. I have no idea why people respect the order of names. But, yeah.
So, kind of back to the objective versus subjective thing. So, what you're saying is applying the objective theory would be there was an exchange because to a reasonable person it looks like they're benefiting by her upkeeping the house.
And the £1 a year,
Yeah, but then subjectively, like maybe the good brother was just trying to be nice, but they don't
Yeah.
care about that.
We don't care about that. And even if objectively it looks like they're trying to be nice, they put it in the form of an exchange, and that's enough. So like if my brother is not evil, but let's say, and nor is he like totally lame, but let's say he's like on the verge of bankruptcy and I want to help him out, but he's super proud and he won't accept a gift from me, right? So I say, okay, look, let's make it a loan, and we draw up some papers that he has to. And everybody knows that this is actually me trying to make, I don't even want him to pay me back, right? But by making it as a loan, he has an obligation to pay me back, and that's enough to make it to make a legal obligation. Even though we even put in the document in consideration of my love for my lame-o brother, right, or whatever, that would motive is different from consideration. Yeah.
You know, we talking like in RE Green, how that was a case where they were kind of trying to find a reason not to enforce that, just.
Yeah, so what's the real difference between In re Green and Thomas v. Thomas?
I feel like this is a case where they would want a reason to enforce it.
She's a mistress, she's a widow, right? The one is a mistress, the other's a widow. Yeah.
Is that, like, how much does the moral side, like, impact cases? Like, it's a pretty big factor, and.
What do you think?
It seems like it.
Yeah.
Well, say like just in light of the case we just read, Cohen and the intent to contract, if the brothers thought, didn't think that they were assuming any legal responsibilities, they thought this was just a gift. So how would that factor in?
Well, first off, we're in England, right? And this is before Balfour v. Balfour, so I don't really know. And under the English rule, I mean, but they did put it in writing, and we've talked about the intent to contract requirement. We haven't talked about what's evidence of intent, right? And so there's context evidence, there's the kind of transaction it is, there's what the parties say. And so where the rubber hits the road in England with their intent to contract requirement is the evidence of intent. And in fact, what courts have since held is that in a normal commercial transaction, we're going to presume an intent to be legally bound. And so the English rule ends up looking a lot like the American rule, right? Because there's a presumed intent in most transactions. This is between, the short answer is I don't know, right? But this is between family members, and that makes it look like, on the other hand, it's not exactly between family members, it's between an estate, right, of a dead person, like the executors in their function as executors, and the widow. And so that makes it look more like maybe arms length and intending, and they put it in writing, and they have these recitals, and so that looks more like they intended it to be legally binding, I would say. Yes, now let's take a break.
Can you provide some clarification on the phrases, like we have motive, we have intention, we have inducement.
Yeah.
We have reason.
I know.
This word.
Yeah.
So I guess
All
reason
those
is
different
like
words.
inducement, right? They're objective.
Yeah, so I want to distinguish first an intention between all of those motive, reason, or inducement, right? An intention, to intend something, is to sort of reach a decision about how you will act in the future, right? It doesn't have to do with your reasons or motives or anything like that. An intention is like a plan that you might or might not share with other people. You might or might not communicate to other people. That's your intention. So with promissory fraud, has to do with whether you intend to perform, not your reason to perform, not your motives, nothing else. Just do you intend to do it? So that's an intention. The other three are kind of similar, right? Motive, reason, inducement. Those are all about sort of explanations for why people adopt certain intentions or do certain things. And the way we're using motive is, so in our, we could, like, all three could be run together, right? What's key is, I could have said mixed reasons here instead of mixed motives, or mixed inducements. The key is, you can have multiple reasons. A mixed motive is where there are multiple reasons, or the reasons that you manifestly have for entering into this transaction are multiple. Some of them are gratuitous and some of them are not. And so that's the lesson of Thomas v. Thomas, that it's okay when there are multiple reasons as long as consideration is present. As long as the lesson of In re Green is at least, there has to be at least one story we can tell about an exchange happening, and there it didn't seem plausible that there was any story, that there was no real, it was just a sham. Yeah.
Intention is also objective, it's.
Any of these can be objective or subjective, right? So when I say objective, what I'm saying is, would a reasonable person standing in the shoes of the parties, knowing what they know, right, think that there was an intention, that this was the intent or not? Intention can also be subjective. So in a promissory fraud case, which we're not talking about today, but still, what really matters is their secret, undisclosed intention not to perform. So the test for promissory fraud is not objective, it's subjective, right? Because you're representing implicitly that you intend to perform. The other side is relying on that representation, but you secretly intend to breach. So for promissory fraud, so it can be subjective or objective. Let's take a break for 5 minutes.
I was like, I interrupted you. Thank you.
Yeah, so what this is so this is the case that we're reading, citing, right? This is reversed by, this is unit, so always, that's the USA. So reversed by this Supreme Court opinion, which is not here. Then it was remanded back to the Minnesota Supreme Court.
And that's when they decided that you couldn't enforce it.
So the US, so what happens is, we're reading this, there are two opinions after this that we're not reading, right? So the Supreme Court, so after this, it goes to the Supreme Court, they reverse, but not the whole thing, they just reverse the First Amendment portion. But so what that means is then it has to be remanded because the Minnesota Supreme Court says no promissory estoppel because of the First Amendment. U.S. Supreme Court says you got that wrong. Then it has to go back to the state court, say, okay, what happens with the correct understanding of the First Amendment? And on remand, you say, yes, you can program for promissory estoppel.
Okay.
Yeah,
But it
we've been
doesn't
told.
get the damage.
Right, I actually don't remember the damages, it would probably have to go all the way back to the trial. Actually, but the first place it goes, it goes.
Oh, I went early. I came in at 7:30. Well, I didn't even notice it. Only 75 minutes. It was so hot.
No,
Right, exactly.
But it doesn't have the primary.
Exactly.
It can be really.
Right, but they did choose to ask for this. Right?
Yeah.
That clearly they wanted to happen.
Yeah. Even
So
though
that
it's not
was-
the primary.
Right, but that was a reason
I
for
would
giving us
fly
that. They wouldn't have done it without that. Maybe, but anyways, we provided them a reason.
As long as they're gonna see it.
Right, so they haven't explained it. But at least one of them was considered. The rest,
that would be explicitly verbalized or?
But it's still like a letter.
I mean, courts around some rules.
Bagels for breakfast, but they're like the same bagels. It's like nothing. Like, I was like, I don't wanna have like that many carbs, and when I go get these little things, bagels, that's the one.
There's some rules, so we're gonna get to like.
No,
what
like,
is-
yeah.
I'm like, bro, I love this. My favorite is
It's supposed to be one law. So, you know, what you're going to see is
I haven't.
Okay, yeah, that was like, that would be like 30 minutes.
So they didn't have to send it back, they just said.
Yeah, I have like go back in.
Yeah,
I've seen so many and then like embarrassing, but then like so many people were like, that's such a good idea. I feel like it's too public, like I'm already awkward. I mean, also like really far from them. Oh, Julie, did you notice that my apartment is no, no. Oh, okay, yeah, yours. That was it's really? Like, it's like a 5-minute walk from mine. It's just like a 6-hour Oh, yeah. Yeah.
Okay. Let's go on. So just two things about, and then I'll take a question on. So first off, we were just looking at what happens to this case to Columbia Cows Media, right? It goes up to the, you can see all this in the heading. It's reversed by the Supreme Court just on the First Amendment. Then it goes back to the Minnesota Supreme Court. So this complex citation underneath the heading shows all that, right? Reversed, remanded. And then the Minnesota Supreme Court says, all right, well, the jury has already found what the damages. Now that the U.S. Supreme Court has effectively said the First Amendment doesn't prevent recovery in promissory estoppel, the jury has already said what the damages are, and so we're going to award them. Right? And then that was the end of the case. And of course, the intent to what the Minnesota Supreme Court is saying in here is that for your action in contract, the reporter promises there has to be a showing of intent to contract, but not for your action in promissory estoppel, right? Because that were a requirement for promissory estoppel. And this starts to show you that promissory estoppel, and we'll see this, starts as a rule about the consideration, but then starts to be used in other ways as well. All right, yeah.
So what is the definition of mixed motive?
So the definition of mixed motive is I'm just sorry, it happens, it's like every day we have mixed motives, right? like lots of reasons why we do things. A single act might have multiple motives, right? A single decision or a single promise or whatever, right? It might be, and the definition is when all that matters for consideration is that there be a motive or a reason. So if you're acting with mixed motives, as the brothers were here, some of which are gratuitous and some of which are not gratuitous, that's okay, there's still consideration. As long as something is being given in return that provides a reason, objectively speaking. Does that help?
So if we,
There you go.
So in thinking about that with Hamer v. Sidway, then it counted as motive because
it was the uncle was, it could be reasonably implied that the uncle was seeking out benefit even though there wasn't any true material benefit? Is that?
Yeah, I mean, well, I mean, the benefit, like, this is where we get this kind of crazy, like, everything you do, you think is gonna,
Yeah.
like a gift, you know, you receive psychic benefit from giving a gift. That can't be consideration, because then
Right.
every gift would be for consideration. All those motives here seem to be complex, right? And you might say they look kind of partially gratuitous, it's out of love for his, but he is clearly asking for something in return, right?
So that motive would be.
And that's, so yeah, it's very easy to tell a story about that being what he's,
Okay.
about that being an exchange transaction, even though like here, in that's the one case we've seen where the benefit is like totally unclear. And that's why it's there to show that it's the exchange that matters, not the benefit.
Okay, got it.
Yes,
So can considerations cancel out each other? So for example, in Thomas, if the brother is really a good brother, then instead of in addition to asking for the £1 and maintenance, he also promised to give the widow back like £5 every year.
yeah,
To
right. So like you can imagine like, and then now, and this is kind of like in Ray Green, where like there's all these big dollars attached to what she's receiving, and in fact, actual dollars, because there's like payments, and in exchange for $1. And then it's hard to tell a story about that, right? So well, we'll get to this right now, but we've already talked about adequacy versus sufficiency of consideration, which is this case. And when it's easy to tell stories about unbalance, like when the things are different, but in exchange of dollars for dollars, that's like, hey, you know, like next week I'll give you $10 if you give me $1 next week. That makes no sense. I'm just giving you $9. So yes, but let's talk about Browning v. Johnson. So I'm out of Rogers. So Jacqueline Sanchez. Yeah.
Yeah.
So right, what's this about?
So there's two osteopaths who are like in a business transaction, and one is, I believe Browning and Johnson entered a contract where Browning would sell his practice,
Yep.
all his materials to Johnson. But later on, he kind of changed his mind, and they entered into a second agreement
Yep.
where he would sell, or in order for Johnson to get out of the contract, Browning would give him $40,000.
Right, so, and I'll just tell you that in my book, like, next to Browning's name, I have an S. The first time it appears, next to Johnson's, I have a B, because we've got a seller and a buyer, it's not always sellers and buyers, like Thomas v. Thomas, they're not. But it's sometimes helpful to know who's the seller and who's the buyer. So the seller doctor, right, wants to get out of this transaction, and so pays $40,000, right, to get out of the transaction, or agrees to pay $40,000, right? And then what happens?
And then he doesn't.
Yeah.
So now there's this issue of they can't enforce that agreement.
Right, and so what does the seller doctor say as a defense? So buyer's like, hey, you said you'd pay me $40,000 to get out of this transaction.
The seller doctor just says, that it was, the second contract wasn't like made correctly. to
Yeah.
enforce it.
Right, and there was no consideration for the second contract, because and why was there no consideration for the second contract? In fact, the district court, the trial court, I mean, finds that, in fact, the first contract wasn't enforceable, right? So I'll just say, that's in this first full paragraph on 122. Right, the trial court concluded that the canceled sale contract had lacked mutuality and had been too indefinite in its terms for enforcement. We don't know what any of that means necessarily, although mutuality has to do with consideration. But what's, and indefiniteness, we'll get to that, but you have to, I think I've said you have to like put enough terms into your agreement so that the court knows what you're actually agreeing to. And that's indefiniteness. So the trial court actually said, well, actually, there was no claim to give up, right? That the buyer here didn't have a right. You paid $40,000, and so the seller is saying, defendant, right, is saying what? There's no consideration, right? And this is like the explanation that we gave for what? Well, this has appeared now twice. Remember in Ray Green? She says, I'm giving up my claim to, based on his promise to marry me after he divorces his wife. And the court says, you never had a claim. And then remember in Hamer v. Sidway, right? I asked the question, wait a minute, why aren't we looking at the second promise? And we said, well, if there was consideration for the first, then there was definitely consideration for the second, right? So those are kind of mirror images. And so it looks like, what's he saying? He's saying, well, this is like in Ray Green, right? I didn't actually give anything up. It was worthless. So why should I pay $40,000? Why should I have to pay $40,000 to give up a claim that never existed, or to purchase a claim that never existed, to have the buyer who's making the claim? Does that make sense? What does the court say?
The court says that the first contract had mutuality, like it was a mutual assent between the two.
Yeah.
So the second contract can be enforced because essentially the promisor, in this case Browning, can't just back away from something if it's not valuable to him anymore, especially because the second person was relying on that
So
too.
yeah, so just because it turns out to be worthless, that's not enough to get out of the contract, right? Just, if you both, well, we'll see, the court mentions mutual mistakes. He was making a bet. He didn't know whether it was worthless or not. It turns out that it was that he paid $40,000 that he didn't have to pay. But he thought that there was a valid contract, and that's enough, right? So we've got this rule for settlement of claims. Well, first off, what's this case? Why is this case in the book? Not just for settlement of claims, but we've got this long discussion of what? Sufficiency versus adequacy of consideration, which we've already talked about, right? When is consideration sufficient? When it's not nominal, when it's more than a peppercorn. Courts ask about the sufficiency of consideration. What don't courts ask about? Adequacy. Obviously, I'm using these now as terms of art, because like what's the sufficiency and adequacy. But we use adequacy to say the fairness of the transaction. Clearly he overpaid, right? But that doesn't matter that he overpaid. We're not going to, same thing with the 1 pound house, right? Maybe that's way below market rent. But we're not going to look into the fairness of the transaction. We just want to make sure that there was an actual exchange going on, not the fairness of the terms of the exchange. So this was a terrible deal, but he entered into it freely, the defendant, thinking that he was getting something, and the fact that he didn't isn't enough, isn't enough to get out of it. Does that make sense? Sufficiency versus adequacy. I should put adequacy versus sufficiency here, right? Those are the two terms of art. But then we also have a more particular rule for settlements of claims. So by settlement of claims, right, release of claims. By settlement or release of claims, what am I talking about? It's that fact pattern that we've now seen 3 times. So what's the rule for a release of claims?
Forbearance, like release of claims is sufficient consideration. Like if you say that you won't do something that you had a previous right to be able to do, then that is sufficient consideration.
Almost, except it turns out that he didn't so the consideration here would be from the buyer, right? Giving up. It turns out that the buyer didn't have a claim for breach, Johnson, right? He didn't give anything up. So it can't be that actually, but he kind of did, but he didn't have a legal right, it turns out, but why?
Yeah, the subjective perception of one.
They believe that, now this is kind of, they believe that there was a claim. And so, as long as the parties believe there's a claim, there's consideration, even if it turns out that they don't, that there isn't one. So as long as, so, you know, if I, like, where's the R in my book? It's over here on 124, right? I mean, there's no one statement of the rule, but it is clear, after this, that paragraph gets indented, the long quote. It is clear that at the time of contracting, the parties equally informed of equally bargaining power and equally assisted by able counsel freely bargained for, freely settled upon an exchange which each felt would be beneficial. That's enough, right? Even if it later turns out that they were wrong, that's not enough to undo it. As long as they both believe that there's a claim there. Reasonably, yeah.
Okay, that's what I was gonna say, so the
Yeah.
difference between in Ray Green would be at the time, they wouldn't reasonably have thought that she had any claims.
At the, yeah, now what I would say is, so how do we distinguish in Ray Green? What does the court there actually say?
The claim that she had was so illegal that they couldn't possibly believe it.
They couldn't have possibly even actually or reasonably, it's just like, it's farcical that she would have a claim. And so it's just another piece of them trying to say that there's consideration when there wasn't, right? There's no way, that's just like a made up claim, it doesn't exist. And so they couldn't have subjectively or should believe that, right? Interestingly, though, if we go back to Hamer v. Sidway, right, the court actually finds that there was consideration, therefore, for the first promise, therefore the second was, but they didn't actually have to go there, right? The court in Hamer v. Sidway could have said, well, when his nephew turned 21, they could have reasonably believed that there was a claim for the $5,000. And under the rule in Browning v. Johnson, that's enough, right? The court didn't have to look into the consideration of the first promise in order to find that the second one was enforceable. Because that settlement of claims, as long as they believe that it might be enforceable. Why do we have this rule? Because we want parties to settle claims, right? Like, what are you doing when two parties, there's a lawsuit, parties are ready to go to court, and one of them says, the defendant says, look, I'll pay you $10,000 if you'll just make it go, save ourselves both the expense of the trial and everything else. It would be a terrible rule if the defendant could always get out of that, could settle the claims, and then later always come back and say, yeah, but I want to relitigate those claims and show that in fact I would have won, and therefore I get the $10,000 back. Right? The whole point of settlement of claims is that you don't have to go through. It's a bet, right? It's like both sides, they don't know how the case is going to come out. Why do defendants settle? Not because they think that they necessarily are in the wrong, but because they think they might be found in the wrong, because there's uncertainty. It's a way of avoiding the uncertainty of litigation. And so we can't have a rule that, just practically speaking, that later allows the person who promised to pay to say, yeah, but, right, I would have won. Yeah.
So, concerning like in Ray Green, even if that they both had some extreme level of ignorance where they thought they were entitled to that claim.
Right.
The fact,
So I hate the way the restatement, this is like, I said the restatement is pretty good. I mean, it's very, very good, it's excellent, but the way Section 74 has the settlement of claims rule. And you'll see it kind of has a subjective and an objective prong. So forbearance, it's not consideration unless, that's like a double negative, never write your rule with a double negative. Forbearance to assert or surrender a claim which proves to be invalid is not consideration unless, or is consideration if. Right? The claim or defense is in fact doubtful because of uncertainties of the factual law, that's an objective prong. If it was a plausible claim, or if the forbearing or surrendering party believes the claim or defense may be fairly determined to be valid, that's a subjective wrong. So if you actually think that there's a claim, that's enough, or of course, if there's a reasonable chance, that's enough. So subjective or objective would be how I put it. And I think what the court is saying in Inouye Green is there's no plausible story we can tell that they thought that this was an actual claim. Yeah.
When they say that the adequacy of consideration doesn't matter as long as it's not constructively fraudulent, is that the same sort of framework as promissory fraud where it's we only care about subjective intent, or could that be
No,
objective?
well, so first off, the rule I just read has both the subjective and objective one, right, to be clear. Where did you do the constructively fraudulent? Where did that language come from?
That is in.
I'm just not sure. The short answer is no, this is all different from promissory fraud.
But
So-
just in terms of being like, what would you have to have in order for something to be constructively fraudulent in terms of adequacy?
Yeah, I don't know, that's why I was asking about where it is, because I'm not quite sure where, in context, that's not a term of art where that we normally use, so I don't doubt that the court uses it, but I think that in Inouye Green, the court might have used language like that, like, because they're saying that this was a motive, but clearly it wasn't.
Mm-hmm.
But I'm not sure that that's where we're saying, yeah.
Is another reason the court comes out this way is that it's very difficult to determine the value of something. Because I may have a subjective perception that something's worth something, but.
Well, so first off, I think in this particular case, right, the settlement of claims, it's very clear that, because the parties have said $40,000. So we don't have that problem in this case. But it is true, right, that very often people pay money based on their subject, or they set the price. People value things in different ways. And kind of in our market economy, we don't tell people how much to pay for things. And we allow people to drive hard bargains. And, while we protect fools kind of somewhat, there is also sort of a caveat emptor still, buyer beware. And so we don't say what's a fair trend, like we the law society. We allow the parties to decide for themselves what's the price that they're willing to pay. And that can be subjectively, that is like we let them decide. We except when we don't, which we'll see that also. Yeah.
So when you say the second clause in section 74 is subjective, do you mean it's like?
I mean, the second sub B, right, where they say, where the rule says, sorry.
It's in page 161.
Yeah. The forbearing or surrendering party believes that the claim or defense may be fairly determined to be valid.
Yeah, so we still judge the belief through a objective lens.
I would say that's actually a subject. This is the first time we've seen a subjective test.
Oh, okay.
They actually believe.
So we can.
Now, of course, let me just say that sometimes, like, it's just too fantastical to think that they actually believe that. That's Inouye Green, right? Like, that's just so crazy. I don't know why Trump always keeps coming up. But like Trump relying, so Trump's defense, right, in the case in DC, is going to be, I relied on my attorney's advice about about everything I did. And what's the prosecution going to argue?
No reasonable person would
No,
believe
not
it.
even no reasonable person. You have to be crazy because your attorneys that you were relying on were Rudy Giuliani and Sidney Powell, right? These nut jobs, and you had the Attorney General and your White House counsel and like really, really good attorneys telling you that they're wrong with the fraudulent electors scheme. And so the argument there. So anyway, it's that is going to be about his subjective belief. That case, that particular prosecution for January 6th events. And the fraudulent elector scheme, but it's going to, the evidence is going to be, you couldn't have possibly believed that because you were picking and choosing the attorneys to listen to, right, based on the advice they were giving you. You weren't really relying on them. It was wishful thinking. all of which is to say that subjective and objective kind of can move, if it's too unreasonable, then you don't even win the subjective test. That's in Ray Green, right? That's the kind of argument that is in Ray Green. Let's talk about Alaska Packers, because I want to get that on the table before we say. Okay, so, all right. Mason.
Yes.
Yeah, Mason, so, right, this is the fishing case.
Yes. So this is taking place in March 1900, and the fishermen are going to be the plaintiffs in this case. And they were contracted with the Alaska Packers Association to man a fishing boat during the upcoming salmon season. And under the contract that they made with the APA, each fisherman was going to be paid $50, and then a few months later, the APA also made another contract with some more fishermen for them to get $60 for them to catch salmon.
But none of those are an issue, right? Because it's actually, even after that, what happens?
Well, then in May of 1900, so a few months had passed at that point, and the fishermen that were all contracted were thinking about stopping altogether with their plan.
Yeah.
And they informed the APA superintendent that they would only resume if everyone was paid $100 each.
So they go on strike.
Basically, yeah.
Right, they go on strike and say, you gotta give us more.
Right. And this put them in a really tough position because the salmon season is very short and they couldn't find enough fishermen in time. So the superintendent said, this is not my responsibility to be making a contract like this, but if that's what you want, then I'll agree to that deal.
Right, because what's important here, the season is short, and where were they hired, do you remember? Yeah, San Francisco, and where does all this new promise happen?
I believe it was Alaska.
Alaska, right? So they're up in Alaska, and what's the thing about Alaska? It's remote, right? It's remote. It's cold and it's remote, and so they can't find new. There just aren't a bunch of like unemployed fishermen around in Alaska. The season's short, so this, as you said, the superintendent's like, I got no choice.
Right.
Right? Because why? What else do we know? Alaska Packers has invested $150,000 in equipment and canning stuff and all of that, right? And all that is just down the drain if they don't catch fish during this very short season. So the superintendent agrees, and then they come back to San Francisco.
And they were all paid their $50 or $60.
They're all paid their $50 or $60, so they sue, right? And now it's kind of subtle. There's the trial court. They win at the trial court, right? And there's that block paragraph. Did you get the trial court's theory? Let's pause on the trial court's theory. Let's go with this court's theory first, right? Because this court says there's no consideration. The fishermen lose, right?
Right.
Why?
The reason for this is the lack of consideration. They were saying enforceable contract requires consideration on both sides.
Well, they agreed to work.
Right.
Or
And
what?
there was no benefit for the APA when they were making that deal.
They just agreed to do what they were already obligated to do, right? So this is the pre-existing duty rule. They had a pre-existing duty to fish for the season. So what were they promising? What was the consideration? They were saying, we'll just do what we're already obliged to do.
Right.
But a pre-existing duty can't be consideration. They already had a duty to do it. So how can it possibly be consideration? So we've got this, it's not just that this exchange was unequal, it's that one side was giving something extra, Alaska Packers, and the fishermen weren't giving anything extra, right? So the pre-existing duty rule says that a pre-existing duty can't be consideration, because you already have a duty to do it. It's like fairly straightforward, that reason. Yeah.
If the facts were a bit different, say the fishermen agree and they're satisfied with the $50, and the supervisor, for whatever reason, says, you know what, I'm gonna up your pay to $100, just because I was so happy with the catches we had.
That's gratuitous.
Yeah, it would just be a gratuitous.
It's a gratuitous promise.
Because nothing else is being bargained for that?
Yeah, it's like you're retiring and we're gonna give you, with no strings attached pension because you did such a great job. Purely gratuitous. Of course, that's not what the court talks about a lot more here, right? What does the court say is really going on? And what's the underlying policy? Yeah.
They were coerced or the superintendent was coerced into making the second contract. It wasn't like he fully waived that.
They're in Alaska, right? So the fishermen, it's not just that there's no additional consideration. I mean, the rule of the case is the pre-existing duty rule, but the reason for the case, right, is we don't want, like, people play this hold-up game. That's kind of the term of art for it. It's a hold-up game, where you enter into the contract. It doesn't always, not every contract gives rise to this, but you allow the other side to invest heavily in reliance on your performance. And then when the other side has no other options, you say, I'm gonna breach unless you give me more. And then that's sort of a form of duress or coercion, yeah.
In the event that like the superintendent used it as like a negotiating point and ultimately got something else from them, he's like, okay, I'll pay you $100. You know, if it is, I think the court would have.
Yeah, what should the fishermen have done?
Like, I don't know, stay extra 2 weeks or I don't know.
Yeah, we'll extend the season by 2 weeks.
Right.
In exchange or we'll paint the boats every week, or we'll, whatever, right? Something more that's not nominal. And then we might say, well, there's still coercion, right?
Yeah.
Like, they don't have to ask for, we know that we don't care about the adequacy of consideration. So as long as the Alaska Packers get something more in return, that, even if it was coercive, right, that would be, yeah. But they didn't.
Right.
They should have. Right, yeah.
I was just gonna say, would that even be valid anyway, because he didn't have the authority to sign the contract?
So there's the question of the superintendent's authority, which is like, this court sort of says it doesn't matter. And so we don't really have a legal holding on the superintendent's apparent or actual authority to pay them more. So let me just say we don't know, right? That's an argument that they were making, but it ends up not how this case comes out, yeah.
I forgot the name of the case with the pensioner for $100 a month.
Yeah.
I saw in the notes that
Like
it eventually got overturned because one of the higher courts believed that the president of the company didn't have the right to give.
So so we're not gonna do agency law, there's a whole area of agency, and it's part of contract law in a way. But the question is, when does one person have the power to bind another person to a contract, right? And that's when they're the agent. That's the term that we use for it. One person can be the agent of another. They have, and so obviously every corporation, which is a non-natural person, has agents, because corporations can only act through natural people. They're the agents of the corporation. And so that's kind of going to be in the background sometimes, but we won't talk about agency.
As a policy matter, if you're trying to avoid the hold-up game, but you allow those like coerced agreements where there's still some objective exchange, doesn't that mean they still could play the hold-up game as long as in return they're like, we need to, for legal purposes, we need to actually do something more, even if the company who's hiring them doesn't want them to, then they'd still be.
Well, we have to be able to tell a story about it actually being consideration, like not just nominal. So we have to, like, a benefit to the Alaska Packers company would be sort of important as part of that story. But even if their motive is because they're playing the hold-up game, that mixed motive, the consideration rule is fairly just rigid. It's just past consideration is no consideration. Add some consideration and you've satisfied the rule. What do we need? We need a separate defense for duress, right? Because that's what's really driving this. And if there's a separate defense for duress, then we don't need the pre-existing duty rule, at least for this purposes, for cases like this. And lo and behold, if you look at the syllabus in the section where we get to defenses, you'll see that there is a defense of duress, but wasn't quite so developed at this time. But the pre-existing duty rule is trying to do something that it's trying to use consideration as a proxy for looking to when there's a holdup, but it's not a very good proxy. Would be a way of saying that, yeah. Yeah.
Like I would imagine there's also like labor laws like governing when like workers are allowed to go on strike, right? Otherwise, like there are like contracts that's like made like after in order to like end a strike would be
Yeah,
void.
1901.
Oh.
Yeah. Yeah. Yeah.
So this case, I guess, has been one of the first cases that introduces us to the term of bad faith in enacting in contract
Yeah.
law. Is this case gonna be?
So in the bad faith is the bad faith of the fishermen, right? Who are just playing the hold-up game, and the idea is that that's bad faith. And this is not a good faith. We'll talk about the duty of good faith in contracting, but this wouldn't even fall under it because it's really more like duress. But what does matter is what's their reason for going on strike. So there's something we haven't talked about yet, which is the nets, right? They seem to have been complaining about the nets. What was their complaint?
They said that the nets were faulty.
Yeah, that they were faulty, but more specifically, remember?
Like the holes in the nets were too big.
They're letting too many fish get out, right? And now the court kind of dismisses this. It says, yeah, but Alaska Packers had every incentive to provide non-faulty nets. Except did they?
No.
Because
they got paid per fish.
The fishermen got paid per fish. So what are Alaska Packers' incentives? So they agreed to them in San Francisco. We're going to pay you whatever, $50 or $60 for the season plus 2 cents for every fish caught. So what are Alaska Packers' incentives?
Catch more fish.
Well, they're trying to make it fish cap.
Yeah, the number of fish. Minimize the number of fish. I mean, Alaska Packers has an incentive to maximize the number of pounds of fish. But this is 1901. What do we know about salmon in Alaska in 1901? There's lots of them. There's just lots of salmon. It's like there's salmon everywhere in Alaska. It's not now everyone wants to catch the little fish, and we have to have laws preventing them from catching the little fish, right? But then, like, if you're a cannery, you're not selling like fresh salmon steaks. You're just like chopping it all up and putting it in a can. So it doesn't matter whether you're catching big fish or little fish, unless you structured the contract so that you're paying your employees on a per fish basis, not on a per pound basis. So actually, the fishermen might have had a good faith reason. Maybe they weren't playing the hold-up game. Maybe they were saying, wait a minute, you told us you were going to pay us on a per fish basis. We had just assumed you'd be giving us like normal nets. I'm just making this up. But you gave us these nets with these giant holes in them, and so we're not going to make enough to, we're going to be underpaid for this season. And then that wouldn't be a bad faith reason, right? They wouldn't be playing the hold-up game. They'd be saying, we just want to be paid fairly. But of course, the pre-existing duty rule would still say no, even if the nets, even if that's the reason, because the pre-existing duty rule is like this mechanical rule. It seems to be, in some ways, like we might say they're not, would we want that, would we want, put aside the supervisor's authority, again, we're just going to bracket that. Let's say that's the reason. Do we want it to be enforceable? I mean, they're still in Alaska, it still seems like there's no other alternative, but they're not trying to extract more than they're due. They're trying to correct a problem in the original contract, which is the problem they're being paid on a per fish rather than a per pound basis. And it's got the incentives all wrong because they don't get to pick the nets. You might say, well, so in some respects, this pre-existing duty rule is under-inclusive, right? If the pre-existing duty rule is a tool to prevent the hold-up game, it's under-inclusive because you could just add a couple more duties, right? And it may be over-inclusive Why? Because sometimes parties who aren't playing the hold-up game might have a legitimate reason to change, the amount paid without changing the fisherman's obligation.
If the second scenario you said were to be true today, I know they wouldn't have this then, but would the fishermen have an argument to be able to say, like, what would they be able to do to mitigate that issue?
Well, so first off, today, and we'll get there, today we'd say this is just a case about duress. We can just look and see, were the fishermen wrongfully threatening to strike or not? Because that's an element of duress, right? And we'll see that the pre-existing duty rule, I've got old rule. The first thing I'll put on the board next time is new rule. This is the old rule. The old rule is very rigid, but it's still there in the restatement, right? 73. Performance of the legal duty owed to a promisor which is neither doubtful nor subject of honest dispute is not consideration. That's the pre-existing duty rule, right? And it's still it's not, again, like I say, old rules don't disappear. They often remain on the books, but we'll see exceptions to it. But today, the company would more likely claim duress. And then you'd have like labor law and the right to unionize and the right to strike, and then we'd be in a whole different, we'd be outside of contract law, we'd be in employment law, which is actually a part of contract law because employment contracts are contracts, but they're highly regulated in a way that's different from the law in general, or from contract law, other contracts. Over-inclusive and under-inclusive in a way, right? But so this is a rule, but at the same time, let's just be really clear, like if you really care about consideration, it makes perfect sense because there was no consideration for the modification. I think that's the first time I've said modification. That's when the pre-existing duty rule applies, when there's a modification. And I'll say when there's a unilateral modification, right? And one side is agreeing to it. The parties agree to change the contract in a way that changes one side's obligations, but not the others. So I'll say that's a unilateral modification, as opposed to a mutual or a bilateral modification. And if you really care about consideration, which, if you apply the rule mechanically and without thinking about the reasons for the rule, then the pre-existing duty rule makes perfect sense because there was no consideration here. So there's A, the mechanical application rule, and B, there's the court's explanation of the rule here, which is it prevents the holdup game. But that's maybe not a great explanation because it's under an open inclusive, right? Because you can avoid it. What did the trial court? Yeah.
They said that they did get something back because you already invested all this money and you would have got no fish. So like, at least you still actualized your investment.
Yeah, but there's a little bit more of a trick that the trial court does. You're right. Clearly they wanted to enter into this. Yeah.
They said that they were liable to damages originally, but then they waived.
When the fishermen walked off the job, they had breached the contract, right? So the idea is, well, at that point, that first contract has gone away. So now they no longer have the duty they've breached. So now they enter into a new contract. Fishermen are agreeing to perform, agreeing to fish. What's the Alaska Packers giving them? Paying them more money and waiving the action for damages that they then had. So it's like a legal fiction, right? The legal fiction is that the old contract has gone away and they're entering into a new, and of course that's, why do I say it's a legal fiction? It doesn't represent what's going on the ground, right? But you can imagine, and in fact, courts sometimes have used this legal fiction to avoid the pre-existing duty rule, right? By saying, yeah, but there's already been a breach, and so in fact that duty is no longer there. But, I'd say it's a legal fiction because that's just sort of like saying that there's no contract, declaring it, ignoring the facts on the ground. But that's what I think, I think what the trial court is trying to do here, right? And that's why the court says no, well, it quotes another, no amount of metaphysical reasoning can change the facts of the case, right? That's just a suspicion. Okay, we didn't do the case of the fine penny, in part because we spent so much time on the no hassle house. We can talk about it next time if you want, or I really invite you to think about it. It's like, that is a totally absurd set of facts. I hope you read them. And inviting